This week's legal lawsuit update involves a proposed federal law that could dramatically affect claims against rideshare companies like Uber and Lyft. I'm attorney Tracy Paulsen, founder of Rightful Legal. The proposal is being discussed as a rideshare immunity measure. More specifically, it's an amendment to a federal transportation bill that would protect app-based network companies from certain state law claims involving drivers. That may sound technical, but the impact could be enormous. Right now, survivors of sexual assault, physical assault, and other serious harm may bring claims arguing that a rideshare company failed to use reasonable care. That could include claims involving driver screening, safety policies, prior complaints, warnings, or the company's responsibility as a transportation provider. The proposed amendment would raise the bar. Instead of ordinary negligence, injured passengers would have to prove gross negligence or criminal wrongdoing by the company itself. That is a much harder standard. Ordinary negligence means a company failed to act reasonably under the circumstances. Gross negligence means something closer to reckless disregard. That difference matters because many injury and assault cases are built on what the company knew, what it ignored, and whether reasonable safety steps could have prevented the harm. The amendment also targets legal theories like common carrier liability and non-delegable duty. Those doctrines can prevent transportation companies from avoiding responsibility simply by saying the driver was an independent contractor and not an employee. That is one of the central issues in rideshare assault litigation across the country. Uber is already facing thousands of lawsuits alleging that passengers were sexually assaulted or harassed by drivers, and the federal Uber sexual assault litigation focuses on whether the company failed to implement adequate safety precautions, background checks, training, safety measures, and responses to complaints. So this proposed law is not happening in a vacuum or isolation. It comes at a time when courts and juries are actively deciding whether app-based transportation companies can be held accountable when passengers are harmed. The legal question is this: should a rideshare company be treated like a transportation company with responsibility for passenger safety? Or should federal law give it a special shield for many claims that would normally be decided under state law? That is why this matters a great deal. This is not just about Uber and Lyft. It's about whether powerful companies can use federal legislation to narrow the courthouse doors for people who say they were harmed during a ride. If you have questions about your potential case or your rights or this impending legislation, you can reach me directly at 617-821-5856. If you found this helpful, please like or share. Thank you so much.